Hey there. I had promised a few months ago to give you guys an update on the Dr Peterson freedom of expression case. I had asked you guys if you thought we should intervene to support the right to freedom of expression. And the overwhelming response to that video was yes, we at the Canadian Constitution Foundation should intervene. So today, I'm really excited to tell you that the court has granted us intervenor status in the case. We will be appearing at the hearing scheduled for June to argue for a robust protection for the right to freedom of expression. I can't wait to tell you all about the case. If you're new here, welcome. My name is Christine and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So I did a video back in, I think it was December, explaining what is happening to Dr. Jordan Peterson. I will link to that video in case you missed it. But in that video, I explained basically everything that's happening. For a brief recap, there were some complaints made about Dr. Jordan Peterson to the College of Psychologists by members of the public, not by any patients of Dr. Peterson's. And the complaints were about public statements that Peterson had made about public figures, politics, climate change, the Freedom Convoy, and things like that. I get into what those comments were a little bit more in that other video, but basically the comments were not about the practice of psychology. But nevertheless, the College of Psychologists of Ontario conducted an investigation and found that Dr. Peterson's statements violated the Code of Ethics for psychologists, and therefore the standards of professional conduct. And the college ordered Dr. Peterson to complete an education program to address what they called issues regarding professionalism in public statements. Dr. Peterson said he will not do that. He will not participate in what he has described as mandatory re-education. So he brought an application for judicial review at the Ontario Divisional Court, challenging the constitutional validity of the Code of Ethics and the standards of professional conduct, which were all enacted under provincial law and are therefore subject to the Charter. From our perspective at the Canadian Constitution Foundation, it doesn't really matter whether we agree or disagree with what Dr. Peterson says. It's about whether these statements can be sanctioned by a professional regulator empowered by government legislation when those statements realistically have nothing to do with the practice of psychology. And the complaints were basically brought by members of the public who just don't like Dr. Peterson. We believe at the CCF that professionals and employees are entitled to their private lives. They have a right to express themselves when they're wearing their personal hats, and they have a right to criticize others in their profession. They have a right to criticize others who put themselves out there in public. And these rights are all enhanced when a charter right is engaged, because these types of statements contribute to public discourse. They contribute to public awareness, and they contribute to public dialogue. They are all contributions in the public interest. Because of the inherent value of individual expression, especially when the charter is engaged, professional regulators, we say, must provide a cogent and compelling analysis that regulating off-duty speech or conduct actually falls within that regulator's mandate. They must also show that the public interest in regulating this conduct is greater than the public interest in upholding charter rights. And we say that that requires a robust evaluation of the contextual factors that situate and explain the off-duty speech and the nature of the profession in which the speech was expressed. As I've said, we have been granted intervenor status at this judicial review to make these points. Now, although professional bodies like the College of Psychologists, but any other body, for example, the Law Society, they have a mandate to protect the public interest, but these bodies, because of the limits of their enabling statutes, they may not regulate off-duty conduct unless they can actually establish a clear nexus between that specific conduct and the legitimate interest of the profession. And where that off-duty conduct engages a charter right, like expression, regulators have a heightened duty to ensure that they have given full effect to the charter protection. We've gone through the case law on professional consequences for misconduct, including by looking at other professional regulators. Administrative tribunals and courts have analyzed context in assessing the off-duty conduct of all kinds of different professions and jobs. Among others, teachers, accountants, lawyers, doctors, and architects. And they've also scrutinized context in assessing whether an employee's off-duty conduct has irreparably damaged the employment relationship. So to summarize those decisions, these different adjudicators have found that those in regulated professions and also regular employees, they have private lives outside of their profession and employment. For off-duty conduct to impact professional obligations or employment, the off-duty conduct must be severe and it must have that nexus to the regulator's mandate or the employer's business interest. And even in cases of severe off-duty conduct, professional discipline will only follow if there is that significant nexus. For example, we found cases involving things like sexual assault, domestic assault, impaired driving, and even a sexual relationship between a school custodian and a 15-year-old student, all which didn't result in professional consequences. This shows the absurdity of imposing professional consequences in a case like Dr. Peterson's, where the conduct the regulator is concerned with is some tweets that strangers on the internet didn't like, and conduct that Dr. Peterson has a charter-protected right to engage in. Freedom of expression is instrumental to a free and vibrant society. It allows for the free exchange of opinions, ideas, and information. Speech, especially controversial speech, is protected and encouraged. Any intrusion into the right of an individual to participate in public discourse, including through controversial statements on social media, must be rigorously examined to ensure that a regulator is not overstepping its mandate. Now, as an intervenor, we can't argue for a particular outcome of this case, but rather for a framework that the court should use to examine the facts in this particular case. We just really want to emphasize the importance of that fundamental value of freedom of expression. You can stay up to date about this case and about all our other cases by subscribing to our email freedom updates at theccf.ca/freedom updates. And of course, you can stay up to date by subscribing to this channel and ringing that notification bell so you get an update whenever we have one. I am really looking forward to giving you an update this June following the hearing in the Dr. Peterson case. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.